Alex here with viewers victory number 4. We have Megan, and her victory involves some things, or several things actually, that the viewers from victories number 1, 2, and 3 didn't actually experience personally. Megan represented herself at an evidentiary hearing. She did use subpoenas. She did question witnesses on the stand, including police officers. Her case is probably a lot more high conflict than any of the other viewers too, with the exception of viewer from victory, or from viewers victory number 1, but he had an attorney most of the time through, whereas she didn't. So I think we're going to get a lot of insight here from Megan, and I'm going to go ahead and the first question I was going to ask for you, Megan, is what was it like preparing the motion that led up to the evidentiary hearing that I just talked about, where you had to question witnesses?
It was pretty overwhelming to get it done. I spent a lot of time in the law library trying to get things prepared.
And you didn't use self-help forms, did you? I'm just curious.
No.
So you okay, so you prepared a custom paper. When you were in the law library, what was it that inspired you to go there and actually do research on your case versus just show up and talk like a lot of people do?
Well, when I found out about case law, I found out that, I could go down to the law library and, pull up different cases on Westlaw. And they also had our state law down there, so it was easy to just reference books, and then the librarians down there were really helpful. Also, in Reno, Nevada, they had a program called Lawyer in the Law Library, and that's where, an attorney will show up for like an hour or two in the evenings, 1 or 2 days a week. One is like for general civil cases on one night, and then another night they have family night. So I had attended a few of those and found that to be a good reference.
So a lot of people who aren't attorneys don't see the value in statutes, rules, and case law. Was that one of the big things that you got from my channel, or did you get that from other sources too?
I'm so sorry?
So when most non-attorneys don't actually see any value in statutes, rules, or case law. So what I was asking was, did you get that from the Proper Person channel, or did you also get it from other sources? I'm just curious.
No, I first got, no, it was first from you.
Awesome. Okay. Now, one of the huge things that I try to tell all my viewers is when you get an order back from the court, something I call an interlocutory order, I always tell my viewers, do not read too much into that order. And you have a really good example in your case, because there was a document that your judge struck leading up to trial. And I recall you being more panicked, more worried about that, because maybe it hinted to you what the judge was thinking, about you as a litigant, or maybe it hinted to you, what was to come when you got to the evidentiary hearing. Why don't you go ahead and let the viewers know, number one, how it impacted you to have, or first tell us what it was that the judge struck, how it impacted you to have that document struck, and maybe also what your urge was to do to rectify it. And then, of course, in the end, you won. So it's a great example to the viewers. Go ahead and let us know what kind of insight you have on that.
Yeah, he struck it, and I just refiled it as my pre-statement or pre-trial statement.
So what he struck then, it sounds like, was like the opposite. No, you would have filed your motion. Your ex would have filed opposition, and then you would have filed a reply. Was it the reply that he struck?
Yeah.
Okay, so I guessed that correctly. And then you just were able to work it in any way at a pre-trial. What do they call it? Pre-trial memorandum.
Mm-hmm. Yeah, I refiled it like that so that it would just be in there, so I could use it. I was really scared though when he struck it. I was really concerned because everything that was struck, I needed. It was like basically all the evidence that I was hearing. So I was really concerned that my witnesses weren't going to be able to be used, that all the subpoenas I sent out would be worthless. I was really concerned.
That's another thing that I wanted to talk about. So you had multiple police reports that were available to you, and I think it was with regards to domestic violence. And you decided, and I can't remember if it was from the advice of the channel or not, but that the police reports weren't going to be enough to win a trial, and that you were going to subpoena the police officers. Is that consistent with some of the advice that you got with your attorney prior? Because you did have an attorney for a short while, and she told you that police reports weren't a problem. Is that correct?
Yeah, at one point she had originally for the case management conference, I did have an attorney, and she actually used police reports, and she told me it wouldn't be an issue to use them, but I learned when I tried to use them during our original family court trial that, I mean, he denied them, and I didn't have a witness there to test. He denied that it had anything to do with him. He actually tried to make it sound like the report was for a neighbor's home.
And people laugh about that because a lot of people say, oh, well, you can use police reports because they're government records, and there are statutes that allow them. There's a hearsay exception. But you just showed how somebody can deny the contents of a police report just by saying, hey, that wasn't me, that was a neighbor. And without the officers there, what are you going to do?
There was nothing to do.
And what's really sad is it worked. So the judge actually bought it. Go ahead.
Yeah, no, it did work. He, I mean, without anyone else there as a witness, like the police officers, the judge couldn't
tell.
Well, I mean, he can't. I don't think that he can make a ruling based on hearsay. Is how they
piece of paper, yeah.
Mm-hmm.
So before I go to the actual manner in which you question the police officers, I wanted to talk more about. There were a couple things here. Okay, so when you went to the evidentiary hearing, my understanding is that the judge did something that is very common. He hinted to you that it would be a good idea to settle, and apparently it was because he went to lunch with one of the experts involved in that evidentiary hearing.
So yeah, at the beginning of the hearing, off record, before we went on record with the case, he said, well, me and the psychologist, we were at lunch today, and a decision is going to be made one way or the other. So how can we get this settled? Is there a way we can just go ahead and settle this out?
Yeah.
And at that point, I was very scared because I thought, what does he mean he had lunch? And so I asked him to clarify, and he said, that they weren't in a group together, some kind of club locally, and that it was a function and that they didn't discuss our case. But what he originally said did not indicate that was the case.
I'm curious, did you question him on the record with that part? Did you get a different answer on the record, or was it still off record?
It was off record.
Okay.
When we went on record and that psychologist was on the stand, he did ask some questions even before I did to square that away. Like, he asked him if they discussed the case outside of the courtroom and that type of thing. But,
yeah.
So that cleared him, but I was very concerned.
Yeah. If anyone here is wondering, any of my viewers are wondering, Megan actually had the same exact district judge I did. So I have a more of a connection to the experience that she went through, because this is just one of the ways that judge, did his job. It was very much, let's just work this out, come to a deal. I mean, he didn't want to sit and preside and make decisions. He just wanted you and your ex to come to an agreement and leave. And it goes along with this idea that these judges have, not all of them, but most, that if the parents agree, then everything must be fine and the kid's okay. And they don't seem to really understand that a parent can agree because they're scared. They're scared that you're not going to listen to them. And then they're going to go and the child's going to continue to be abused. And you as a judge might think everything's fine because they're not back in front of you, but the reality is far from that. So now, I've mentioned this earlier, but you may have gotten scared, but you proceeded and you did eventually win. So let's talk about that psychologist a little bit more, because this is something that happens to a lot of my viewers. Well, number one, a lot of my viewers get scared and settle because the judge intimidates them. But number two, a lot of my viewers will get a letter from an expert that their ex has. And that letter from the expert will say things that will concern the viewer. In this case, what did the letter that the psychologist prepared say?
Well, it was supposed to be, it was titled like an evaluation, which to what I understand, it wasn't done properly the way an actual mental health evaluation should be completed. But it basically said that there was no resentment towards the children ever. and that he and his wife had a great relationship, really healthy relationship and everything. But I mean, the night before there were altercations involving the police just the night prior to the evaluation being done. So essentially it was there was actually two recommendations. One of the evaluators didn't show up to the hearing and the other one did.
Well, I'm definitely going to touch on that in a second. But
Yeah.
also, the letter that you did get and the evaluator that did appear, he made certain statements which you just stated would have been damaging to your case because it basically puts your ex in a false light. But one of the things that I tell my viewers is a lot of these people who go through these evaluations, they don't tell the whole truth. They leave things out. So in your case, what you did was you questioned the evaluator on some of those things that your ex most likely left out and didn't tell him, and that changed the evaluator's opinion on the stand. So why don't you go ahead and elaborate on that for the viewers?
Well, so I just presented some of the information that I knew he wouldn't have had ahead of time, and so I couldn't just make statements to the evaluator, so I had to think of questions that would lead up to that. So, for example, I'd say something like, "You determined in your evaluation that custody with the children is recommended. Would you agree?" And of course he said yes. And I'd ask a few other questions that align with what his evaluation was, where he would say, yes, I agree with that. I agree with that. And then I would say, now, had you been informed that the police had been at his home due to domestic violence the night before, would you have made the same decision? And then I would just I would kind of frame my questions like that. And
It worked. He changed because you said he changed his mind after you asked those questions. He said, "Yeah, go ahead."
So of course he couldn't say, if there was abuse happening and there was, substantial alcohol consumption happening, especially leading to violence, he couldn't recommend that would be a home, that he would recommend for the children. And so the question was asked, had he known, would he make the same decision? And he obviously said no.
And that's one of the things that I stress to people. Do not freak out if you get a letter from an evaluator. What you can do is just subpoena that evaluator to appear in court and ask him the questions that the information that the ex is going to volunteer. And once an evaluator finds out, oh, wait, they left out like 16 different domestic violence incidents, they left out a conviction, all of a sudden the evaluator is going to say, hold on, none of this was told to me. I changed my mind. And it's just, you handled it really well. Now, in your case, go ahead.
One thing I might want to add too is that he wasn't even on. So my ex had filed a document admitting his resentment towards the children, and the evaluation didn't even address that. And when I questioned the evaluator about it, he corrected me, saying that there was never any. And so then when in his motion that he had approved the evaluator on it, based on that information, his honesty that his client had with him. So since your client hasn't been honest about these things, you feel like he can't be honest with himself and he can't be honest with you. Would you agree that, he should be unsupervised and have the ability to influence the children in that way? So basically, I kind of forgot where I was going. Sorry.
No, you made, like, I got a comment from somebody saying amazing point that, so you did good. I mean, you painted a picture for people. And I mean, it's frustrating for me because these are judges. They should expect that this is a possibility. It should cross their mind. Maybe this expert wasn't told everything. And,
Mhm.
the reaction that you got from the judge at the end of this evidentiary hearing was completely different than what he started out with. And it's like,
Yeah.
really? Did you not think this was possible? Like, people
I
tell,
was really scared because when I walked in there, I knew that he already had an opinion. I already knew that he had, in his mind, made a decision about what was going to happen that day. And I was nervous. I mean, I really had to trust myself and the evidence that I had brought in and know that, I was doing the right thing by protecting the children. And so, family court's not easy at any level, but then you have, you mix in all these other, high conflict issues, and it really, it's hard on everybody, but
yeah,
it's definitely difficult to go in and litigate for yourself. So I just made myself kind of like an outline of the most important points that I needed to hit. Because sometimes when you're in court, you get interrupted by the judge.
yeah,
Um, your opponent will interrupt you, and in my case, I felt like the judge sometimes would just allow him to do it, and I would never be able to get back to that. So, I had like a pen or a highlighter or something, and I just kind of like check off those issues as I brought them up, and I put the most important ones in the order they should be brought up in. So that was kind of helpful as well to have. And then obviously, I had written out my questions, at least the most important ones, ahead of time, and having the police officers there was huge. If I wouldn't have had them there, we would not have. I know we wouldn't have had the same outcome because
so
he
I
would
didn't
deny
even
the
get,
reports like he's done before.
yeah, I didn't even get to that. We just did the evaluators. Now tell us how the police officers, how many, first of all, how many showed up? And second of all, what did they testify to? And how did you use that testimony to win your case? That's huge.
We had 4 police officers there. 3 of them testified, and I'm sorry, what was the second part of the question?
Well, you're going into it. You're basically you're letting us know how many were there and exactly, what did they testify to? How did they help your case?
Okay, so they testified to, what happened at, what was in their report, and I think actually all 4 of them testified. Initially, he requested to call in one of the officers who wasn't the officer who ended up doing the report. So we ended up having to call the 4th one in.
Okay.
Just because even though we had police officers there, he still denied some of the things that were in the report. He, like, for instance, he said, well, how do you know it was my house that you were at? And so I had to ask things like, is this the same person that was at this residence when you opened the front door? Do you recognize Mr. Larrigett? Is this the person who was there? Because he was literally even denying that it even happened, even with the police officers there.
I mean,
Oh, I'm sorry.
the gall, like that's just such a, like that goes, like some people try to bend the truth, but to just complete that, to just say that wasn't
Yeah.
me is, yeah.
I mean, and the questions that were asked by him were like, well, you respond to a lot of calls in this neighborhood, you know, you respond to, it's a big apartment complex, how good is your memory on this particular instance? Because, wasn't this for the neighbors and not me? He tried it again.
Mhm. Well, and in this case, I can't remember, but were there a multitude of domestic violence convictions going back through the years with him, or was that with his new partner?
There was an arrest in our relationship. There was no conviction, but a history of domestic violence. And so,
Okay. So I wanted to pause you right there because you know how many of my viewers tell me, oh, well, there was just an arrest, they dropped the charges. And so my lawyer said, or the judge said, we can't do anything about it. That wasn't true, was it? You were able to prove that domestic violence was a factor in your case without a conviction by using the testimony of witnesses, right?
yeah, eventually, I mean, in the beginning, because it wasn't a conviction, it, it, it should have been viewed, at least from how I understand things, as domestic violence. But at that time, the judge didn't rule that he had committed domestic violence in our relationship. And so that was frustrating because I knew that it was happening in the current relationship, and it definitely impacted the children.
Mm-hmm.
significantly.
Yeah.
But the thing is, you know, the history just continued to repeat itself. And so, you know, it was easy to show. There were just, I mean, they were together for 2 or 3 years, and so there were several instances where the police had to show up to intervene.
That's another thing that I always tell people. It's if you are going through issues with your ex and they have problems with domestic violence or drugs or crime, oftentimes after the separation, they continue to do those things. And I'm always telling the viewers, maybe you weren't able to prove it in your case, but if they are as abusive and neglectful as you say, it's going to continue to happen. And in your case, you were able to pull examples of domestic violence occurring after your separation. I stress this constantly. Not only do you not need a conviction, but you could even look to, incidents that haven't even involved you, something that they've done with somebody else, like you did in your case with him and his new partner.
Mm-hmm.
So, let's take a look here. Another thing that I wanted
her custody case was in front of the same judge. And coincidentally, they had just had a hearing actually in her case, maybe 2 or 3 months prior to that evidentiary hearing that we held. And so it was just kind of like by happenstance, the judge had heard about a lot of this and had actually reversed child custody in her case back to the father. So that was like 2 or 3 months prior. And he actually used her testimony because she didn't show up in our hearing. I forgot to tell you this. He used her testimony in her own hearing in our court order. So even though she didn't show up as a witness after she was subpoenaed, her testimony in another case was still used.
Okay, so I'm not going to, I'm putting a note here to talk more about the subpoenas, because there's 2 people that you commanded to appear that did not appear. And this is a very technical issue that has ruined self-represented parties' cases time and time again. But before I go into that, we got a comment from Ali. He's asking, did you have to get a psychiatric or psychological evaluation? And is that why you had mental health experts? So I think he means to ask the question as in, did your ex have to get a psych eval? And if so, is that why he had mental health experts? Well, okay, you can go ahead and answer that. You get it.
Yeah, so I didn't personally have to get a mental health evaluation done. My ex was required to do that in order to, move forward with any request to be involved with the children. And he had 2 done. They weren't done properly, so your state might have different parameters on what different criteria on what a mental health evaluation should look like. But
I'm curious.
Yes, if I had one done, and then what was the second part of the question? I'm sorry.
Oh, what I'm curious about is the whole requirement for your ex to have a psych evaluation. Was that prior to the evidentiary hearing, or was that something that came up after the evidentiary hearing? Because that's something that I'm curious about. Go ahead.
It was prior to, because initially he had filed to terminate his own parental rights. And because of, the circumstances, the order was written that he couldn't terminate on himself without proving certain issues, including fault. And so what they did was suspended his visitation. And said that if he wanted to file to see the children again, he would need to motion the courts with an evaluation.
Okay, that definitely answered the second part of his question. So yeah, for Ali, her ex had tried to terminate his own parental rights, and throughout the process of doing so, the judge questioned his mental health, ordered him to get an eval, and that's where that became relevant when she came up to an evidentiary hearing later on. So the conclusion.
See, Alex is so awesome. His wording is fabulous. If I can do it, you can do it too.
I can't tell you guys how many times I have to redo my videos, but for some reason when I'm doing live streams, I guess I do pretty good at explaining stuff. I don't know. But There was something else that I wanted to mention. Oh yeah, so the conclusion of the evidentiary hearing was that you got primary physical and sole legal custody and his visitation was suspended. Am I correct about that?
Mm-hmm. Yeah, his visitation wasn't, like, he didn't, his motion to get visitation was not granted.
Okay.
And yeah.
So how much did you spend in attorney fees on that?
On that hearing?
Yeah, just on that hearing.
None.
There you go. That's what I wanted people to hear. So $0 in attorney fees. And a whole lot of people just don't think it's possible. And that's the whole point of the Viewer's Victory series, is to show people that it's not just me, that other people have been able to go to court, represent themselves for free and win. And I want to stress, this wasn't your choice. I mean, if you had $1 million lying around, you would have hired an attorney. But you represented yourself because you had no choice.
Yeah.
Yeah. So I did promise to get into the subpoenas, and I really want to do that because this is important. Many, many times I will hear from self-represented people, they will go to court and they will have expected witnesses to appear, and the witnesses don't show. And every single time that this happens and I review the case and I take a look at what happened, the first thing that the judge says is, did you subpoena the witness? And if you say no, you have not preserved that issue for appeal now. There is nothing that you can do. The judge can say, well, too bad, so sad, now you don't get testimony, and if you lose your case, there's nothing you can do. But in Megan's case, she subpoenaed all of those witnesses, and this forces the judge to do one or two things. The judge has option A, which is to send a marshal out there to find that witness and haul them into court. Or they can continue the hearing to give you another opportunity. And then the other choice is the judge can find a way to work around the fact that the witness didn't show up. If Megan had not subpoenaed those witnesses, I can guarantee you that this judge would have said, no, we're done. This is it. You should have subpoenaed them. You didn't, and you need to come to an agreement. The judge was already indicating he wanted the parties to settle and just go away. And the reason that he didn't do what his instinct was is because you forced him to use the law. By using the subpoena, his arm was twisted. And so he decided to work around the non-appearance of the two witnesses. Number one, you had one evaluator appear. So what the judge did was he figured, since you asked two to appear and one showed up, that was good enough. Now, there are ways to fight this. If you don't get testimony that's favorable to you, you could always say, well, I need the other evaluator. But in this case, the evaluator that testified provided very useful information on, that helped your case. So Weller was allowed to, at that point, say it's okay that the other one didn't show. This one bolstered Megan's case. The other witness was your ex's new partner. And that was a huge deal because of all the domestic violence involved and all of the documentation indicating that she was doing things that were harmful to the child. So the judge worked around that as well. What he did was he recalled testimony from another hearing. What the subpoena does is it forces the court to either get that person in there using the long arm of the law, sending deputies out there or marshals, or to find ways to work around the fact that the witness hasn't showed up. And that would not have happened, Megan, had you not subpoenaed those witnesses, because time and time again, I see what happens to self-represented parties who don't subpoena witnesses. And just letting you know that you doing that was crucial to your victory. So let's take a look at the next thing here. Oh, so there's a couple things that I wanted to touch on. Your case involved using, and I've heard of other people doing this, not very often, but it happens. Your case involved using the fact that somebody connected to your case had another case that was open. And in this case, your ex's new partner had another case that was open. I'm curious, to what extent did you communicate with her ex, and to what extent did that help you in your case?
I mean, we really didn't communicate at all, except for the common denominator that his ex was in a relationship with my ex, and it was affecting both of our children. And so it was kind of one of those things where, major things we would communicate, just because we were generally having the same problems, like visitation being withheld, especially during holidays and things like that. So, I mean, I don't want to say like we got together to like plot against or anything, but it was just kind of like we would just get a pulse on what was going on. And because it was happening in one case, we could use it as evidence in the other. And I mean,
And I think
it,
you even mentioned that it affected her custodial rights as well. Apparently, she lost custody of her kids to him in that other action, right?
right.
We got a comment here from a viewer. We actually have two. The first one is asking, how did this work out financially? They want to know if your ex was ordered to pay you child support.
Yeah. I mean, he was ordered to pay child support because he doesn't see the kids. So at the time, when he left the children with me, though, right before he filed to terminate his own rights, I was child support. We had 50-50 custody, but our incomes, you know, were different. And so I was paying him. So he actually was receiving child support still while I had the kids full time for a while until that was
Yeah.
changed a little later.
Yes, that's a pretty common situation. So
Yeah.
you were originally having to pay under the Wright v. Osborne formula that we have in Nevada, and then after the custody was modified, then you started to receive. The follow-up question from that viewer is, did your ex actually pay the child support that he was ordered to pay?
Yeah, I mean, he worked for the guy that he worked for was also a friend of his. So they, were putting a lot of money under the table. Sometimes, and the checks were really inconsistent, even though they were under garnishment from the child support division. So, if you can get a garnishment order, you can just request it. It's pretty easy to do. If they're not paying, that's the easiest way to deal with it. If they're working under the table, it's kind of harder, but it
Yeah.
should be easy to get a garnishment order from the child support division. And then you don't have to deal with any of that. I mean, like in the very beginning, when we separated, he was paying child support, but he'd kind of like whip me around on that too. Like he would get a money order for the date that it was due, and then he wouldn't give it to me for like a month. So he could like go back and say, oh, look, I paid her on this date, but I didn't receive it, till later. It was just kind of like little things like that to mess with me. But I mean, all in all, that really doesn't matter to me as much as, the kids just being safe. But the reason it matters is because it just kind of goes to show like the situation as a whole, like everything was just like played dirty, like
Right.
I'd get motions that were typed in like size 5 font,
What?
like stapled together all crazy. Like I got like one or two of them like that. Um, just weird things like that.
I'm laughing
Um,
because my ex did the money order thing too. She said she gave me 3 money orders that she never did, but she took pictures of them. So she actually went through the trouble of getting the money order and taking the picture, but she didn't give them to me. And then later
yeah.
on, when it came up in court, we called to see if they were cashed or anything, and they weren't. So we can only assume that she got the money orders, spent all the money, took the pictures of them, and then destroyed them, like shredded them and threw them away or something. It's
It's
just
just games.
it's beyond insane the extent that they go to just mess with you. But
Yeah.
so another question that I had here is, you had to, this is something that comes up a lot too with the viewers, you had documents that you needed to use, but the problem was that those documents, and they showed abuse and neglect or something along those lines, the documents that you needed to use were not prepared by your ex. They were prepared by your ex's new wife. And when you tried to use them in court, go ahead and let the viewers know what happened, because this is something that I warn people about too.
Which ones? You said when I had to use them in court.
You tried to use documents that your ex's
Oh,
wife had prepared.
yeah, yeah. So, because she wasn't there to testify, I couldn't use them.
And it's that simple.
I had subpoenaed her to be there, and she did not show up. It
Oh,
would have been detrimental to his case for her to show up. So that might be why she didn't. I'm not really sure. Maybe they weren't getting along or something. They divorced not too long after that, but I wasn't able to use them. And the judge. So I even tried to, just like have him, like my opponent, read it on the stand. But the judge didn't have it. It was just treated as hearsay, basically, just sort of like the police reports. So it's really important to have your witnesses there.
So in this case, you subpoenaed her, and she didn't show up, so she violated the subpoena. But I'm curious, was this at the same hearing where all of the officers testified and the evaluator as well?
Yes.
Okay, so this is why the judge did that then. Okay, so because you won your hearing, the judge knew that he could go ahead and let it slide that she didn't appear. And the reason why is because what he did was he committed an error, a legal error, but it's harmless because it didn't affect you. You already got everything you wanted, you already won. So the judges know these details. So he basically allowed your ex's wife to violate a subpoena by you having won everything that you were asking for anyway. If the judge had not done that, if he had ruled against you, you would have been able to file an appeal because you subpoenaed that witness. You had documentation that was important and would have impacted your case, and the court would have abused its discretion and not compelling that witness's appearance. So that's another, it all ties in to the fact that you have to get people in the courtroom if you want a strong case, even where, in this case, there's no hearsay exception, but even in other examples, like where you have police reports which provide hearsay exceptions in the law, or which the law provides hearsay exceptions for, you can still see how somebody can word their way out of something. There was a comment from somebody about the
Somebody
narrative.
that plays dirty will never follow the rules. Like somebody that just wants to play games and, you know, is naturally abusive. I think that in a lot of cases, the courtroom is kind of like an extension of the abuse that happens during the relationship. You know, your ex will use the court to, you know, utilize a sense of control that they don't have over you anymore. And anyway.
I'm going to go through some of these comments. Some of these I can answer. Ali says, was he pro se or were you? So Ali, your answer to that is Megan was representing herself. I think he might have been as well, but for the purposes of this video, this live stream, it's covering Megan's representation of herself in court. TC is asking how long did it take? So I guess you could let us know how long, I mean, you're still in the middle of it. So how long has your high conflict child custody dispute gone for?
It started at the tail end of 2013.
Oh my goodness. So you're looking at 6 years.
Yeah.
And counting. Is it a lot more peaceful now that he has left his ex? Because apparently she was the one that was kind of pulling all the strings. And yeah, so it's calmed down a lot more for you then. All right.
Yeah. Well, and the other thing too is that he doesn't have any custody, you know, and he, I mean, I don't get nasty emails and stuff like that. It was really like her writing everything in my case.
Mm-hmm.
All of the emails, all the communication was from her. I mean, he just kind of like disappeared off the face of the planet once we had that ruling, and then they separated. So
Perfect. Okay. So then a couple more comments here. Daisy says that your case sounds just like hers, that her ex committed domestic violence to his, I guess now ex, twice, and then he went to jail. Yeah, and so so Daisy, it's the same situation. Your ex is getting into domestic violence incidents after, you know, or before, either way, and you can use them even if the police just arrested him and there were no charges, or even if he went to court and he even beat the charges. You can still use them in a civil case. You can still try to prove it yourself, like Megan did. Daisy confirmed. Oh, go ahead. Go ahead.
And I used that. I forget what it is, but I used that statute too, or case law that allows you to bring back up past history of abuse, because there was violence going on in his house. I was able to bring back up the violence that happened previously too. So I reminded the court of a lot of the other things that had happened because of all the, you know, violence that was continuing.
Yep. What you're probably talking about, and I can do this because we're in the same state, is Castle v. Sims, which is the case that talks about res judicata principles in the context of abuse or domestic violence. So yeah, you had to kind of control the court on that a little bit, because I mean, I'm not sure how it was with you, but when I was in front of that judge, anytime my ex's attorney raised res judicata or issue preclusion or anything like that, he just bought it and just denied whatever it was I was asking for. So it's good to see that in your case, he didn't do that, because Castle v. Sims and there's other case law out there says you can't do that as a judge. If somebody has new incidents that have occurred, then you need to address those new incidents. You can't act like, oh, well, since it was talked about 2 years ago. That's it. You can't bring it back up.
Well, the reason it didn't work for me before was because of the police reports. They were just reports that were considered hearsay. You know, I didn't have the officers there to testify, and he denied everything.
Right.
So I couldn't say like there's like existing violence that was happening, you know. And so,
you know, a lot of people tell me, hey, I went to court with police reports and I was just fine. And what I always have to tell them is, well, what did your ex say when he was asked about it? Because a lot of times the judge will ask them, what's this all about? And then the ex will say, oh, well, Your Honor, I got into a fight and this and this. And what the judge is doing is he's using the testimony of the party against him. But in your case, your ex said, that wasn't me.
Nothing's easy.
So, you know, it's what, like, a lot of people get confused and think, oh, well, I used police reports and it worked out just fine. Okay, well, that was for you because your ex just went and admitted everything. But not everyone's ex goes up there and says, yeah, everything in the police report's true. Some people have an ex like Megan who says that's the wrong guy. And so now there you are with a piece of paper that you can't question. And so we got another question from Jen here. Can you subpoena any time before the court date, or does it have to be during the time of discovery? This is a great question. You can subpoena well, there's two types of subpoenas, and from what I understand, the rules are a little bit quirky with both of them. So the subpoena ducas tecum, which is to command documents to be produced, that has to be done during discovery. But when you want to subpoena a witness to appear at a hearing, from what I've seen, it's a little bit more flexible. The only thing that matters is that it's the right type of hearing. Make sure you don't subpoena a witness to appear like at a case management conference. You have to figure out what type of hearing you're going to. And if it's an evidentiary hearing or a trial, then yes, you can subpoena witnesses. There probably is some threshold or some time limit as to how soon or how close to the hearing you do that, because the opponent has a right to object. So like if you try to subpoena somebody, your opponent has a right to quash the subpoena. And so if you do that like a couple days before a hearing, they might, you know, object and say that it prejudices them because they didn't have the opportunity to look into it and you know, try to quash it or something like that. So the rule of thumb is check your rules, because you're going to have court rules in your state that will tell you the details as to when you can do this.
And my ex tried to say that he didn't get anything too. He tried to get him thrown out. He said the same thing every hearing we had. Oh, she never served me with anything.
Right.
So, I mean, I got an affidavit from the people that did the service, so that I had an affidavit with the proof of service that I filed, because that's just the way he is.
Yeah, so, you know, I've seen that you're not the only one. I've seen some videos on YouTube of other people who go to these hearings, and the high conflict ex, they just fight everything. Oh no, we're objecting all the evidence. No, I didn't post that on Facebook. No, that was somebody else. They hacked my account. I've seen that before.
Yeah. Well, and the people I had do the service too, I would put them on standby during the hearing in case the judge needed to make a phone call to confirm that service was actually done, because that's how much he denied everything. I knew that he would deny it every time. And if I didn't have someone to verbally testify, it could potentially be an issue.
That's another thing that I tell the viewers. If you know your ex is you know, a certain type of person, anticipate the response. I actually have a video. And so that's what you did. You just prepared. You planned out all of the possibilities, you know, everything that he could possibly do. And to the best extent that you could, you had, you know, things set up ahead of time. And that's a genius move, because that does happen. And in your case, the judge probably just believed you, but sometimes the judge may want to actually make a call, or they may even want the person to come in and testify, which is a really risky move for your ex, because if one of those witnesses walked in and took the stand and pointed a finger at him and said, yes, I gave him this document on this date and time, that he's done. The judge is going to think that your ex is a liar, like a bold-faced liar. So I was curious about a lot of times people will have these cases with an ex who isn't really the person who's doing everything because they want to, but it's their new partner who's really the driving force. And with a lot of the viewers, they feel bad for their ex sometimes, or they feel like it's not as bad because their ex loves their kids. But really what this comes down to is a duty to protect, you know, and in this case, it's your duty to protect your kids. And your ex's inability to protect his kids. How did that sort of How did that really impact your decision making going through your case to know that it wouldn't have really happened this way had it, not been for his new wife?
Well, I really blamed myself for that because I mean, like the way I looked at it, like I loved his family so much. I never wanted them to ever look back and be like, "Oh, she blah 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 blah." So I never filed anything for child custody in the courts. Like my thought was like, don't rock the boat and cause a fight if there's not one, because we agreed on the visitation. Like things were really rocky when we first separated. He wasn't like he was doing some really stupid things. But once that time period kind of like passed and we had like some continuity and like things were going okay, it was just kind of like don't rock the boat, everything's good. And then but what you can't control is who they end up with. And so if they end up in an abusive relationship, or if they end up in a relationship with someone that doesn't want you on the other end being able to make decisions that they want control over, and like with disordered individuals, generally that's, I mean, like control is a big issue for them. And so if I had just filed our agreements, none of this ever would have happened. If I would have just said, okay, this is our schedule, we're just going to go ahead and file a stipulation that we both agree to this, it never would have been changed.
Wow.
And so if you're like in a separation, or if you're separated and you don't have a court order, I would highly, highly, highly suggest like saying, hey, look, we both agree on this. Let's just go ahead and put it in writing. Let's, set it all up. it's it's not gonna hurt anything. And you know what? Like some of his family still, like cares and keeps in touch, and some of his family is distant, and it doesn't even really matter anymore.
Mhm.
Like all that matters is what ended up happening as a result of us not taking care of that.
Yeah.
And so it disrupted the schedule that they were used to. And then it subjected them to all kinds of stuff that should never have ever happened. And
Right.
so I mean that's like the biggest takeaway is to just avoid it all if
Yeah.
you can.
I tell
You
people,
know?
if you agree with your ex, just prepare a stipulation and file it. There's no stress. There's no drama.
Yeah.
They
Yep.
it's like, you know what though? I think a lot of people are worried. Like if I try to put this in writing, they might change their mind. And what does that tell you? If you feel like
It
you
tells
can't,
you
go ahead.
it tells you that that's the very reason why you should do it. Because if you're
Yes.
scared to do that because things might change, just imagine like when there is nothing in writing. I mean, what if you're not married and someone just picks up and moves out of state, or doesn't want to return the kids, or starts filing like false TPO reports, or I
Right.
mean like whatever. Who knows what's going to trigger a person,
Yeah.
especially if they have substance abuse problems, because they're like people with substance abuse issues are so unpredictable. The things that happen just don't make sense. Anybody, like, you just can't be reasonable with unreasonable people, in other words. And it's better to just protect yourself.
And that's such a big clue too, is if you have a document that has the agreement as you've agreed to, and it's ready to go and your ex refuses to sign it, that's a big red flag. I have this in two different videos, that your ex is preparing to backstab you. If you have
Mm-hmm.
come to an agreement verbally and they don't want to file that with the court, they have a plan. They've concocted a scheme or a plot, and that piece of paper is going to get in the way of that. And so that
Mm-hmm.
set off so many alarm bells for you to start moving fast and institute proceedings before they do whatever it is that they're trying to do. So yes, I mean, like a lot of people are so afraid of court, but what they don't understand is there's documents that you can file that you don't even go to a hearing. The judge just signs it. Like you file a joint petition, most people within a week or two have a decree or a judgment, and that's it. No hearing, no stress. You pay like 100, $200. If you can't afford it, you can even get that waived. And now you have a binding enforceable order. And I don't know. Part of me thinks people just don't know. And then the other part of me thinks people, it's like what I just told you, is that they're afraid that they're going to change their mind. And all those points he made were totally valid. I mean, it's like that tells you that's why you have to get in writing. So we got some more comments here. The first one is, I recommend anyone who put in a court order to make sure that you put down everything that you want, because it will be a pain to go back and change it. It's absolutely true. You definitely want to get all the details in there. And then we got Daisy. She says, thank you. And she also says something about her previous relationship. Okay, so I think she's commenting on the domestic violence stuff that we were talking about earlier. And then Jen says when she was first taken to court, she agreed just to look good to the judge. Big mistake. That's a big mistake that all of us make, including me.
I was afraid that he would look at me in a bad light, like I didn't want to agree or settle.
Yeah.
You know, and hang on.
And they can't remember you anyway. So like I would agree, thinking, oh well, the judge is gonna, think highly of me, and next time I come to court, he's gonna remember I was the guy who agreed with everything. I was the guy who didn't want it to turn into a fight. No, next time you're back in court, they've completely forgotten who you are and everything that you did just to get the judge on your side. No, they can't remember that. The judge.
Well, and not only that, everybody gets punished when you go to court. It's like you're punished because you're both here.
Mhm.
And you don't agree on anything, so now I'm going to make a decision. And like they have such a degree of discretion for the most part that, I mean, like you said, studying the law is really important.
Yeah. And well, you've done good because you're an example to the viewers that it helped. And I think we're about to wrap this up. Looks like we're just under an hour, and I'm not sure that there's much else to cover here. I think I covered all of the comments. So
Sorry about that.
That's okay. At this point, we've covered all the comments, and I think we're ready to wrap things up, unless you want to let the viewers know anything else.
I mean, I can't really think of anything except for what I wish I would have done differently is like kept like all of the weekly sheets, like from school and everything that we're supposed to be signed off on. I wish I would have like had like one folder for that kind of stuff, and then like one folder for like all medical, and I don't know, just the way I sorted things. I guess if you think about the way you're organizing all of your documents as you go along, it really matters, especially if it gets super complicated, because I'm sure you can probably relate, Alex. You end up with a lot of paperwork.
Mm-hmm.
And so like having all of your like proof of service in one place, and like all of your motions in a different place, all your orders. We ended up with a lot of that stuff.
Yeah, I had to go in like with this, not a suitcase, like I wasn't to the point of a suitcase, but it was one of those big like things that you could buy at Staples, those things that carry folders inside of them. They're like expandable, they're like accordions, and they stretch open. I had one of those. It weighed like 60 pounds. It was full of so much paper. Yeah, you do have to have all that organized, because it comes up, the littlest thing will come up, like certificate of service wasn't filed, Your Honor, and now you have to like look and prove that it was. Sometimes those attorneys literally just forgot that you filed something. Like, they're not always trying to be evil. Sometimes they will. Sometimes they'll just lie and say you didn't give them something that you actually did, but on other occasions they just legitimately have no clue. And so to have all those little documents is a big deal. And of course the school stuff too. So you got a thank you from TC, and then basically from Jen as well. I guess at this point, guys, we're going to go ahead and sign off. And if you have any questions that you want me to forward to Megan, just send me an email at admin@theproperperson.com, and I'll go ahead and do that. So I'll see you guys next time. Thanks.
Bye.